regional treaties that Kenya is a party to that can be used to advance sexual and reproductive health rights. So, some of these rights that are protected include the right to health, which also includes the right to sexual and reproductive health, the right to found a family, the right to bodily autonomy and integrity, the right to make free, informed decisions about reproduction, family planning, as well as freedom from violence, which also includes sexual violence. And all these are contained in some of those international treaties. Now, in cases where you can't directly use those provisions of the law, you can actually use indirect provisions such as the right to access to information, the right to equality and non-discrimination, the right to privacy, the right to life, the right to human dignity. So these are some of the indirect constitutional or international treaty provisions that you could use to advance sexual and reproductive health rights. Now, some of the constitutional rights that are relevant for sexual and reproductive health rights include the right to health, which also include the right to reproductive health, the right to personal security, the right to freedom to make decisions about reproduction, equality and non-discrimination again, the right to life, the right to human dignity, freedom from torture, privacy, and all that. So all those rights are contained in the Constitution that you can use to advance sexual and reproductive health rights. Now, just moving on to some of the key changes that we've seen in the law, specifically in relation to Kenya. So in 2015, we had the Protection Against Domestic Violence Act, which provides legal redress for gender-based violence in private spaces, including marital rape. Now, in the past, what you'd find is when you go to complain in hospitals as a wife and you say, look, I've been raped by my husband, most of the times this was not seen as rape. The assumption was that because you're married, then you cannot be raped by your spouse, which is not the case. So the 2015 Protection Against Domestic Violence Act actually provided redress for gender-based violence within private spaces, and that was very key. That was a very key change in the law in Kenya. Then in 2016, we had the SADC Model Law on Child Marriage, which provides a blueprint for SADC states for laws to eradicate child marriages and to also deal with its consequences. So this was very progressive in outlawing child marriage within the SADC states. And then in 2016, we had the Sexual Offences Amendment Act, which provides enhanced investigation and management of sexual offenses. So it also provides for a gender neutral definition of sexual offenses, and it also has provisions for public education and information on sexual offenses and sexual education in schools. So this is very, very important in the sense that, especially the part that emphasizes the gender neutral definition of sexual offenses. You know, sometimes people believe that a man cannot be raped because it's a man. It only applies to women. So those are some of the issues that we've faced over the past few years that this law has now sought to eradicate over time. And then we also had the 2017 Health Act, which codifies constitutional provisions on access to health and reproductive rights. So it has enabled the effective recognition of sexual and reproductive health rights and also the enforceability through the courts. So the courts have been able to use the act to actually uphold and interpret constitutional rights, including access to safe abortion and the rights of survivors of sexual abuse. And then in 2021, we had the SADC Model Law on Gender-Based Violence, which provides a framework for SADC states on laws addressing gender-based violence. And in 2022, we had the Children's Act, which has the legal recognition of intersex children and the protection of their rights. So this was very, very significant because it also led to the subsequent amendment of the Births and Deaths Registration Act, which has the legal recognition for intersex persons. So what you'd find is that when you're going to register your child, they'll ask you, is your child male or female? And at that point, you can't really say whether the child is male or female. So you had those instances in which those children are not protected because sometimes you could go and, register the child as male and the child actually grows up to be female or vice versa. So this was very important in that aspect. And then some key court decisions that we've had. So, one thing I can note and highlight is the fact that Kenya has had the most progressive case law when it comes to sexual and reproductive health rights as compared to the other 8 countries that we did in the policy brief. So it's had the most number of cases, and it's very broad. And these are some of the things that we could actually use to advance more sexual reproductive health rights in other states or in neighboring states. So, firstly, in 2018, we had the COI and GMN versus Principal Magistrate Ukunda Law Courts and 4 others. And basically, in this case, the Court of Appeal ruled that forced anal testing was unconstitutional and it breached human dignity. And then in 2019, we had the FIDA Kenya and others versus Attorney General and others, in which the Constitutional Court confirmed the legality of abortion in sexual violence cases. And it ordered the restoration of abortion care guidelines. So, what had happened is that in 2014, the country had abolished the abortion care guidelines. And in this case, the court had ordered the restoration of the abortion care guidelines because of some of the challenges that women were facing in accessing abortion care. And then in 2021, we had the Dr. Tatu Kamau versus the Attorney General and others, in which the Constitutional Court upheld the ban on female genital mutilation and affirmed the rights of women and girls to freedom from violence through harmful cultural practices. So that was also significant in, abolishing harmful cultural practices such as FGM. In 2022, we had the PAC and another versus Attorney General and 3 others, in which the High Court affirmed that the blanket criminalization of abortion, including in cases of pregnancy resulting from sexual assault, was inconsistent with the Constitution. So this case affirmed basically what the 2019 case sought to do as well. And then in 2023, we had the NGO Coordination Board versus Eric Gitari and others, in which the Supreme Court upheld the right of LGBTQI plus people to form and register organizations. So this one is very, very important because in most of our states, like for example in Malawi right now, LGBTQ communities cannot register the organizations because the assumption is that they partake in activities that are criminalized. Therefore, they cannot have an organization, of which that shouldn't be the case. It's misinterpretation of everything. So in Kenya, particularly, you can register an LGBTQI organization. And then also in 2023, we had the SWK and 5 others versus Medicine Sans Frontiers. Now, in this case, okay, the case disappeared, but I will definitely send the slide to you. Okay, so moving on to the case at the African Court. In 2020, we had the advisory opinion on vagrancy laws in Africa, in which the African Court on Human and People's Rights affirmed that vagrancy laws breach the rights to dignity of poor and marginalized communities, and that they are incompatible with the African Charter on Human and People's Rights. The case specifically recognized the specific impact on sex workers and gender nonconforming persons, and it broadened the interpretation of other status in the prohibited grounds of discrimination in the African Charter. So that was important, particularly for that reason. And then some of the persistent issues that we face is, first of all, the high rates of maternal deaths and severe injury. We still have gender-based violence and harmful cultural practices, regardless of the laws that, exist. We also have stigma and discrimination against key populations, and also maintenance in the use of criminal laws that penalize sexual conduct and status. And lastly, we also have unsafe abortions still taking place, even though, the laws and the court cases have happened. And basically, it's the legal uncertainties and the contradictions that create fear amongst women to seek abortion care, and also for healthcare providers who are afraid to, be on the wrong side of the law. So those are some of the persistent issues that we are facing in Kenya. Now, some of the other issues and the legal barriers to healthcare that we're experiencing is the inconsistency between the law, policy, and practice. So basically, what you find is that there's a war or a struggle or a fight between the age of consent to sex versus the age of consent to sexual reproductive health services. Now, in Kenya, particularly, the age of consent to sex is 18, and the age of consent to sexual reproductive health care services require parental consent. Now, this creates a problem in the sense that you find that young people younger than the age of 18, cannot go and seek healthcare services, basically because they are afraid of being asked to bring their parent, you know? So basically, they're not being able to go to the hospital to say, look, can I please get, you know, healthcare services for this issue or that issue, because they have to go there with a parent, and that shouldn't be the case. So this is some of the issues. These are some of the issues that we're facing in different African countries. As well as if you look at the policy brief, which I think Velo you can share on the chat, um, you will find that there's this battle between the two. So this is particularly specific to Kenya, but in the policy brief, you'll be able to compare it to other countries. And then, okay, so some of the legal barriers to accessing health for women and young people, we have the access to abortion in Kenya. Now, abortion in Kenya is provided for in Article 26(4) of the Constitution, which states that abortion is not permitted unless, in the opinion of a trained healthcare professional, there is need for emergency treatment for the life or health of the mother, or if the health of the mother is in danger, or if it is permitted by any other law. So abortion is not necessarily a crime in Kenya. You can seek abortion services for those reasons. However, you find that in terms of Section 158 and 160 of the Penal Code, which predates the Constitution, abortion is illegal. So you find that there's a contradiction between the Penal Code and the Constitution, which is saying, look, you can seek abortion services on these conditions, whereas the Penal Code is saying no, abortion is illegal. So, as I mentioned earlier, the government withdrew the abortion guidelines in 2014, and basically the guidelines provided for clarity for the provision of legal abortion care and, issues like that. So the courts have attempted to provide some clarity. I mentioned some key decisions earlier. That's the FIDA Kenya and others versus Attorney General, as well as the PAC and another versus Attorney General, which both affirmed the permissibility of abortion within the set circumstances in the Constitution. And it also confirmed the inconsistency of maintaining a blanket prohibition on abortion, including in cases of sexual violence. However, regardless of these cases, we still have issues in accessing safe abortions in Kenya. So, we also have issues in the laws that target persons living with HIV. Now, you find that
Viv, are you aware we can't hear you? Your mic is closed.
oh my goodness, I'm so sorry. I'm so sorry about that. Okay, so did you hear anything at all? Or should I just start over the slide? Okay, it's fine. I'll just start
I
over.
think you should start over. Sorry, Vivian. You got cut off right at the beginning.
Oh,
Yeah.
okay. Okay. All right. Thank you so much. So we also have overboard and unjust laws that target persons living with HIV. which increase stigma and discrimination, and it also negatively impacts the access to sexual and reproductive health rights for persons living with HIV. So this also subsequently affects the HIV prevention and management programs due to the chilling effect of criminalization. Now, within section 186 of Kenya's Penal Code, it basically provides that if you perform an act that could spread a dangerous disease, whether you unlawfully do it or you negligently do it, you could be charged with a misdemeanor. So basically, if you get involved in sexual activity, whether you know or you don't know that you have HIV or any other dangerous disease, you could be, arrested for that and you could be charged with a misdemeanor, which then creates a bit of a problem in terms of also the rights of persons living with HIV. And then you also have the issue with transgender and intersex persons facing difficulties in acquiring legal documents, such as identity documents that match their gender identity. So the mismatch between the gender presentation and the identification pronouns leads to barriers in accessing government initiatives. So this is what led to the act that I spoke about earlier, the Registration of Births and Deaths Amendment Act, in which now it recognizes intersex persons, but now the issue is now with them recognizing transgender people, because you go there and you say, look, I am female. And the person will say, no, but you look like male. So those are some of the issues that we're still facing in the countries and in our societies. And then we also have emerging issues, largely due to the cut of, funding cuts because of Trump's administration. We have, the closing of the civic spaces. So we have public law orders that restrict activism, including protests, online speech, media communications. And the civic space in Kenya has been impacted by government crackdowns on protests and leading to arrests, forced disappearances and deaths. So there have also been crackdowns on LGBTIQ plus expression and assembly. And this is a very big issue that we're facing in not just Kenya, but in other African states. And then the funding cuts have also affected funding for CSOs, and they've affected advocacy and service provision provided by CSOs. So you'll find that in most of these countries, NGOs or CSOs are the ones that are providing healthcare services to minority groups such as the LGBTQ community or the sex workers. And now, because of the closure of these places, they are now forced to go into public spaces or public hospitals, which they ran away from to begin with. So these are one of the issues that we're currently facing in these countries. And then we also have the emerging anti-rights movement that is advocating for against sexual and reproductive health rights, gender equality, human rights, and all those that affect basically key populations. So the movements are largely funded by US and European ultra-conservative groups, and they're characterized by the spread of hate speech as well as misinformation and lobbying of political, professional, and religious leaders across Africa. So they're basically using, religious leaders, political spaces, and other people to lobby against sexual reproductive health rights. So one such example in Kenya is the George Kaluma versus NGO board and others, in which this parliamentarian unsuccessfully petitioned the Supreme Court to overturn the judgment affirming LGBTQ rights to associate. So basically, the previous case in which the Supreme Court said, you know what, you can register your organizations, this particular person was saying, no, you need to overturn that. So these are some of the instances in which we're facing in these different countries where, we have leaders, people at the top, people with influence, trying to influence the rest of the country to, go against sexual reproductive health rights. So they also introduced a family protection bill in 2023 in Parliament to also curtail sexual and reproductive health rights and LGBTQI plus rights. So the notion around there is that, okay, a family consists of a mother, a father, and children, male, female, and children, or male and female who are married together who have children. And they don't want to recognize the fact that there can be families there that consist of LGBTQI persons. So there's also a growing organization of regional conveners in Africa that are funded by the US conservative fundamentalist groups that appear to influence legislative changes restricting SRHR. So one of such convenings was held in Kenya in May 2025, in which it resolved to advocate for the revision of laws and policies in Africa to undermine gender equality and SRHR. So these are some of the emerging issues that we're experiencing in terms of the anti-rights movement. So yes, basically the funding cuts that I was talking about. I will skip this slide just for time. And then how do we respond to the crisis as NGOs, as advocates? How do we then say, okay, let's, advocate more for sexual and reproductive health rights? Firstly, we could reinforce and ring-fence human rights principles and standards that have been developed through the years. So the principles such as equality, principles such as non-discrimination through advocacy in the courts. As I mentioned earlier, Kenya has been one of the countries that have been progressive in using the courts. We've had more cases in Kenya than in any other country. So it is important that we use those cases to our advantage. We use those cases and also add on to the international principles and standards so that we can advocate more for sexual and reproductive health rights. We also have a progressive constitution in Kenya. Use that to your advantage. And also the government's willingness to be a party to international human rights norms and treaties. As I mentioned earlier, it's party to the CEDAW, Maputo Protocol, all those international covenants. Those are some of the provisions that we could use. Also, we could use regional advocacy, like what we're doing now, having webinars with the different countries. It's just a matter of bringing all these countries together and figuring out how do we progress from here? How do we move from here? How can we then, use these laws that have been created in different countries and help them, apply them to our countries that don't have the laws, or apply them to countries that haven't had such court decisions. So those are some of the ways that we could do this. You can also have community empowerment. Self-advocacy is important because it's one thing for NGOs or CSOs like ours to do advocacy on behalf of sex workers, on behalf of minority groups such as LGBTQI community. But if they themselves do not stand up and say, look, we exist, these are the problems that we're facing, these are the lived experiences that we're facing, then it doesn't become as impactful. So it is important that as LGBTQI persons, as sex workers, as migrants, whatever minority group that you come from, you need to also speak out. You need to have the voice to say, look, this is what's going on. This is what needs to change. So those are some of the ways in which we could respond to the crisis that we're facing. And having said that, I will end my presentation here. Thank you so much for listening. Mvelo, over to you.
Apologies.
Angela, I think,
Yes,
sorry.
I'm here.
I thought I was going to say you muted.
Oh yes, I thought my mic was unmuted. Thank you so much, Vivian. That was very insightful. I think everyone can reflect based on what you said. Also, please feel free to say something in the comment section if you had some feedback from everything that Vivian shared. So Moving on, now we will talk about lived experiences. We'll give it over to ICJ Kenya to now give the experiences on how these issues have in real life affected people.
So my name is Christine Akinyi, and I work at ICJ Kenya, which is a civil society organization and a membership-based organization that promotes human rights, democratic governance, rule of law, justice in Africa. So now we work with other CSOs to advocate for the right to health in Kenya. And for this webinar, we identified a civil society in Kenya that works with key populations on issues of sexual and reproductive health rights. So with us today is Hortense Minishi, who is the Deputy Executive Director and Head of Programs at the Kenya Legal and Ethical Issues Network, in short, KELIN, an organization committed to promoting and protecting health and human rights and women rights through strategic advocacy, legal interventions, and community engagement. She's a seasoned human rights lawyer with close to 15 years experience. Hortense is passionate about protecting human rights and the rule of law and advocating for social justice, particularly for unrepresented, vulnerable, and marginalized groups globally. She has multiple certifications in law, human rights, arbitration, mediation, and civil leadership attained across Africa, United Kingdom, and from prestigious programs like the US Fulbright and US Mandela Washington Fellowship. She brings a wealth of expertise to her work while championing women's rights, civic space, and leadership. She has over the years led and supported human rights projects that are aimed at countering gender inequalities and power imbalances. And in 2022, she was awarded the International Exceptional Women of Peace Award by Pathways to Peace, an organization with the UN ECOSOC status. She's a feminist and a Pan-Africanist at heart. Her dedication, strategic mindset, and commitment to positive change define her professional ethos. She strives to live by a mantra to leave a little spark wherever she goes. So Hortense will be speaking on behalf of KELIN. She'll be explaining to us the work KELIN does in relation to sexual and reproductive health rights with a focus on key populations. So Hortense, you can take over the mic and share your experience working with key populations.
Thank you. Thank you, Christine. Are you able to hear me?
Yes, I can hear you clearly.
Thank you. So greetings to everyone. As Christine has introduced me, my name is Hortense Minishi. I work at an NGO here in Kenya called KELIN. In full, it's the Kenya Legal and Ethical Issues Network on HIV and AIDS. KELIN was founded back in 1994 informally, and our work largely touched on the lived experiences of persons living with HIV. At that particular time, there was little known about what HIV is and what are the legal implications of the same. Over the years, we have helped develop the policy and the act on HIV, the HIV Act of 2006, I believe. And our work has then expanded to also other key affected populations. So our broad mandate is around the right to health and health-related human rights. So we've expanded our portfolio to also work with women and girls generally, adolescents, as well as other key affected populations such as sex workers, persons injecting drugs. and LGBTI groups. So our work mainly uses interventions around litigation. And I think I saw Ms. Nyokabi Njogu, who was initially part of the KELIN litigation team and led some of the cases there. And we also do a lot of work around the advocacy and campaigns work, just creating more awareness about the issues around SRHR, the laws, the rights at the community level, and also influencing laws and policies at a duty bearer level. So in terms of the lived experiences, I think I'll take, and I'll start from where Vivian ended in terms of, yes, we have the laws that exist and they provide a strong baseline for protecting SRHR and also protecting key affected populations. When you look at the legal frameworks in Kenya, we have quite, and she mentioned that Kenya is a very progressive, state in terms of having these legal frameworks. So we have the international instruments, we have the regional instruments, we have the constitution, we have domestic statutes that provide this protection around SRHR, and it's almost gender neutral. It looks neutral in terms of it affords this right without discrimination. However, in practice, the lived experiences of people is different in terms of even just actualizing and enjoying this right, the right to health, and in extension, the right to sexual and reproductive health. So some of the challenges that have continued to be there and that KELIN has tried to advocate on relate to one, stigma and discrimination. So I'll speak to instances for persons living with HIV, despite laws that say there shouldn't be non-discrimination, they should be treated equally. There have been cases where persons living with HIV have been discriminated upon, and the stigma around the HIV status is very alive in their communities. So in two instances, so one of the cases that we worked on was a case relating to cost and forced sterilization of women living with HIV. Here, women were forced to undergo tubal ligation without their informed consent. And it speaks to two vulnerabilities. The vulnerabilities around the HIV status, that they were living with HIV status, and they were misinformed, around what happens when you're carrying a child and you're HIV positive. And then the other vulnerability that plays in is the aspect around the gender aspect. These were women as well, and it speaks now to the maternal aspect and maternal health and how we envision aspects around violence that women who are bearing children or who are pregnant undergo. And we at times just think of it as normalized within the community. So KELIN has been working a lot on this and has expanded its work to ensure aspects around stigma and discrimination by building more awareness about these issues, but also advocating on an issue called obstetric violence, which is wider than just forced and coerced sterilization. It speaks to more harmful practices and attitudes that are linked to maternal health care to ensure that women undergo or are receiving dignified maternal health care. Another case that speaks to aspects around stigma and discrimination, especially for persons living with HIV, has been linked to aspects around recruitment practices. And this was a case where we were challenging the Kenya Defense Forces employment practices. And one of the things that happened is our client was subjected to mandatory HIV testing, which is something that the statute, the HIV statute, does not allow. You need to give consent if you want to undergo HIV testing, but this was not done. And therefore, once the tests came out, they were not given the opportunity then to take part or continue into the recruitment. So this case has recently received a favorable decision where the court determined that, you know, this was discriminatory and the Kenya Defence Forces need to put up a policy that is linked to non-discrimination for persons living with HIV. So there's still a lot of work that needs to be done, a lot of awareness creation that needs to be done in terms of the lived experiences of persons living with HIV. Despite laws being available, it does not mean that they are not facing stigma, that they're not facing discrimination. And I've only spoken to one specific group, but even other groups, you know, other marginalized groups, other vulnerable groups, still continue to face this kind of issues, still face, you know, stigma and discrimination. Another key challenge that comes about in terms of the lived experiences of persons living with HIV is the aspect around criminalization. And this comes around because of the restrictive or contradictory laws. I think Vivian alluded to it when she was giving the presentation about how, in terms of our constitution, for example, on issues of abortion, there's a clear aspect around Article 26(4), which allows for safe and legal abortion. However, when you look at our penal code, it's very restrictive and punitive. So therefore, people or service providers who would want to assist, healthcare providers who would want to provide the services, as well as the people who would want to procure safe and legal abortion, are afraid to do so because of the criminal element. So it stops being in reality being a right and becomes a crime. And therefore, this is a big challenge in terms of how then the law moves away from actually providing protection and centers punishment instead. So in this aspect around the abortion work, we've also really worked a lot in advocating for respect of the Constitution. Vivian mentioned the case around the PAK case, where the court affirmed that it's a constitutional right. And therefore, one of the things that needs to be done is that harmonization of statutes and harmonization of the Constitution, so that then one legal framework is not speaking a different language from the other one. Another key challenge when it comes to the lived experiences of persons or key affected populations is the aspect around restriction on access to services and information. And here I'd like to put focus into the groups of adolescents and young people where third-party consent is needed. Vivian alluded to it when she was talking about, you know, aspects around the age of consent and how this is appearing in the National Reproductive Health Policy 2022 to 2032. So here you'd find that one of the things that Kelly has done is to challenge the RH policy on both procedural and substantive grounds. This means that in the aspects of procedure, we felt that lack of public participation, there was a lack of public participation where the key groups affected by this policy were not included in the policy-making processes. But in the substantive aspects, there were key groups also who were left out from the ambit of protection of this framework. And these mainly were the adolescents who then would require parental consent. And this brings a challenge in terms of what if they're not able to access it? What if, you know, they're adolescents who do not have parents, and therefore it then restricts the aspect around access, the actual access to services and information for these particular groups. The fourth thing that affects lived experiences of persons, care-affected populations, would be the aspect around weak enforcement. So we have this robust legal framework, both from the international, regional, domestic level. And then we have the court rulings. You know, the pronouncements are seemingly progressive. And while these are there, they get ignored, the court rulings get ignored, they're not enforced, they're not implemented, and therefore the orders that are put there become just, you know, paper-based. They're not really translated into practice. Therefore, this means that what is supposed to reflect into society as a key change ends up not being done. or even just the implementation of a progressive law, whether it's aspects around non-discrimination, whether it's aspects around equitable access to health. Not every county, not every national government continues to implement these laws as envisaged, and therefore there is a big gap around the implementation aspects about these policies, about the rulings and the orders that we receive that continue to advance protection for key affected populations. The last thing that I'd like to touch on in terms of the challenges would be the aspect around financing. Earlier this year, I think most of us were, or at least got to hear about the USAID funding cuts and how that has impacted, healthcare programming, including SRHR programs and HIV programs. And this has led to a lot of uncertainty about the future of healthcare programming. So there is a push for governments to obviously raise their domestic financing so that it can meet what is expected of them at the regional level by WHO standards, by the Abuja Declaration. But until we get to the point where we have sustainable financing and not donor dependent, there's still a gap around how healthcare programming will be accessed. And the people who suffer most or who bear the heaviest burden are the marginalized and vulnerable groups or the key affected populations. Because if there is financing, if there is domestic financing, usually you find that they're excluded sometimes within the ambit of that protection. And if there is none, then they are completely left out. I think we have the SHA conversations in Kenya happening, the Social Health Insurance Fund that is supposed to kind of provide universal health coverage. But even if you look at the brackets for services for certain conditions, they're very low. And then if you also look at the terms of who will be contributing and how they would be contributing, indigent populations are also left out because then they won't have sufficient monies to contribute to this. So this puts the aspect around, yes, we have the laws, but then can we truly access the services that we need? So there's a big gap there in terms of even just accessing the actual services that people would require when it comes to enjoying their sexual and reproductive health rights. So then how do we fix this? I've mentioned aspects around our strategic litigation work that Kellyn has continued to do. We've been very intentional in terms of doing public interest cases, which then speak to the larger population. The benefit goes beyond an individual. The cases we've worked on are some of the ones that I've mentioned around the persons living with HIV, women who are discriminated upon. We've also done a lot of work around persons or LGBTIQ persons. We also did a petition to the Parliamentary Public Petitions Committee on the subject around LGBTIQ infiltration in Kenya, and we are waiting to possibly be given a chance to speak at the committee floor on these issues. But the things that we need to continue to do in terms of strategic litigation, we believe that it's one of the tools that is key in terms of producing progressive rulings and more law around this, because then it continues to give us a basis for defending rights and ensuring that everyone enjoys the right to health and reproductive health. The second thing is that alignment, legal realignment around laws and policies that are contradictory or inconsistent. As mentioned earlier, there's that bit around safe and legal abortion, and there are many things that influence the pushback around people wanting to actually implement that aspect around the Constitution. Some of which is around misinformation. I think many of the people just read Article 26 on the right to life as the first slide and do not go until the aspects around Article 26, for which then permit safe abortion in aspects where the life and health of the mother is in danger or in cases of an emergency. And therefore, there's little information and little awareness around this. So it's key that we realign these laws so that they speak and are harmonized with the Constitution of Kenya, which is the supreme law of the land, so that there's no confusion and people are not afraid to offer services for the fear that they'll be, under national status, that they would be found liable or, be subjected to a felony or a crime. Another thing that we could do in terms of fixing what is currently not working is aspects around strengthening enforcement and accountability. As mentioned earlier, one of the key challenges for key affected populations enjoying, this robust legal framework, this legal protections, is the weak enforcement. So there's a big need to hold duty bearers accountable, to continue advocating for transparency in policy making, so that we have the public participation as key and central to the policy making processes, so that the key affected groups and communities affected by certain legislation or policies are consulted and are informed of the policies and what it means for them. The third thing that we could do in terms of ensuring a more transformative legal environment and policy environment for key affected populations is aspects around inclusive and participatory policy making, which I've already alluded to. We need to ensure that the people who are affected by these laws and policies are at the center, so a people-centered and the right-based approach in terms of our policy making processes. The fourth last thing we could do is aspects around investing in health financing, which is central to ensuring that then key affected populations can access the services that they need at the time they need, and that these services are affordable to them. So there's a big need for civil society organizations to continue advocating for adequate health financing, but also that for governments to prioritize health and health-related needs as a key priority when they're doing financing and budgeting. The last thing relates to the systematic barriers around stigma and discrimination, and this mostly would relate to how even the opposition, the opposition and the anti-rights movements are linked to the work and how then what they end up doing curtails or limits the enjoyment of these rights. So there's a lot around capacity building and creating awareness of rights that needs to be also done, so that as society, we're not only looking at the laws, but we're looking at the cultures, the attitudes, the behaviors that then continue to block or hinder key affected populations from enjoying their SRHR rights. So overall, while there is a robust, legal framework, and we are progressively continuing to see stronger court rulings, they still need in terms of the practice, and that's where the gap is in terms of that enjoyment. There's need to ensure that even in practice, that this is just not, a paper, but this is actually, and it's not just a promise, but it's actually a lived reality for the key affected populations. So I'll stop there and I'll be willing to take any questions. Thank you.
Thank you, Hortense, for the very insightful presentation. So we'll take questions after all the speakers have made their presentation. So kindly just note down your questions, and then we'll have a question and answer session at the end of the webinar. So we'll move on to the next session, whereby we'll be listening to Ms. Valentine Nyokabi, who is an advocate of the High Court of Kenya and a human rights lawyer passionate about sexual, reproductive, and health rights. She has extensive experience in sexual and reproductive health rights, litigation, and advocacy. So she will be speaking to us on fighting for our rights, litigation, and advocacy strategies. So Valentine, you can now share your presentation. Thank you.
Thank you very much, Christine. And I just want to also stand on the protocols that you've observed but also just to recognize that my former boss has just spoken before me. It's been a pleasure to listen to you. Christine, I'm having a problem sharing my, hope it'll work now. Let me try. I was trying to share I just made a brief presentation. And I hope, Christine, you can just confirm that you're seeing it.
Yes, I can see your presentation.
Oh, wonderful. So I think what I've been asked to speak about is on my experience litigating and conducting advocacy on SRHR. While I was previously at Kellyn, I currently am now at a different organization, working as a legal advocacy advisor for Africa and doing both litigation and advocacy for SRHR. So I will speak to some of the cases that Vivian and Hortense have mentioned, as well as some strategies that I think may be useful. So when we think about what effective strategies for influencing policy and public opinion are, we need to start from a point where we think about grounding this in solid evidence. And here, when I think about advocacy, I consider strategic litigation to be a very important advocacy tool. And I like to say that, it's this tool, it's like a toolbox where you sort of pick and choose what is most appropriate for you in terms of the job that you want to do. So we need to ground this in solid evidence if we're going to have what effective either litigation or other out-of-court advocacy strategies. And this means that we have to invest in research, we've got to invest in data, and we've got to find a way to record the lived experiences of people. And this is one of the things that gives our strategies credibility, both in and out of court. Secondly, we need to frame our issues, both in and out of court, in a way that resonates with the people that we want to listen to us. So we shouldn't be framing our issues in terms of like we only want to speak to ourselves who are part of the choir. We need to speak to the people and explain to people why our stories resonate. Because whenever you're doing advocacy, you're not just speaking to policymakers or duty bearers, but you're also speaking to the lay people, the public, about why the problem that you've highlighted is a significant problem, but also why it needs to be resolved and what practical solutions are available in terms of solving them. Thirdly, we need to think about movement building. Whenever we work in sexual and reproductive health rights, we've learned the hard way that we need to do this in a manner that we are carrying everybody along. Because whenever there's regression in one area, that regression also affects all other people. So we need to work with civil society, we need to work with communities, and we need to also figure out who are our allies within the duty bearer framework that we could possibly leverage on. And then we need to have sustained engagements. And I'll speak a bit more to this a bit later, but I want us to think about now I'm not sure if most of our audience is Kenya, but in Kenya especially, and I know also in Uganda, court decisions take a very, very long time to be rendered. And the court process generally is extremely technical because we've inherited an adversarial colonial system. So it's extremely technical, and we need to think about what sustained engagement looks like. So whenever we are designing our advocacy campaigns, how do we do them that they're just not one-off campaigns, that someone had something about a year ago, but also that we can do it in a sustained manner that could actually help us shift attitudes. I think what we have found is that the most successful advocacy strategies have to be grounded within lived realities. That's one. And I think Hortense has spoken a bit in terms of what we did at Kellyn in terms of leveraging on wins, especially around HIV discrimination. But also you need to take an intersectional approach, because the person that you're representing is not just what they are. So if it's a person living with HIV, they're a person who probably needs an SRHR service. They probably are an older person. So we need to speak to that lived reality in terms of what this particular individual means and translate that reality into a language that other people could potentially understand. In terms of how do we make sure that we are actually recording our lived realities? How do we take people's stories and shift them into a manner that people actually understand. There's a saying that while facts can move minds, so like the courts, but stories are the ones that really resonate with people. A lot of times it's a story that's going to remain. Even when we do strategic litigation, the reason why we like to have a person is because that story sticks in your mind. Both Vivian and Hortense have talked about the story of the women who underwent forced and coerced sterilization. So for those of us intimate with the case, we may know that this is a problem because these women were, they were violated in terms of their right to bodily integrity. But the real question for many people usually is, but how did they find themselves there? So when you find out how they were forced and they were coerced, it's a really touching story. That's usually the story that sticks with you. And I do remember even in terms of whenever we'd go to court, and even the judge would remember oh, this is that case that involves those women living with HIV, because the story had stuck with him. So that lived reality in terms of what someone has gone through, it humanizes a very, very complex issue. It explains to both lay people as well as to duty bearers why the issue that we're discussing is extremely important. It can be, I don't like using this term, but it can be a bit voyeuristic. It can be very, it can look like you are capitalizing on someone's heart or someone's pain, but there are ways to frame narratives and to show why issues are important by making them more relatable and therefore shift public opinion. In issues such as SRHR, which sometimes are extremely stigmatized, this is extremely important. Whenever we're advocating for safe abortion, in a country that I think Desagu has said that, anti-rights rhetoric is extremely strong here. But so you're going and telling people are not asking for just general abortion on demand, but we're asking for abortion as healthcare. And you explain why this is important. That sort of humanizes it. And I do believe that the council in both the JMM cases and PK were able to demonstrate this, that this was a girl who needed an intervention, a healthcare intervention in terms of post-abortion care. But then what happened to her that she was eventually arrested. And in the case of JMM, the girl actually died. That story is what sort of sticks with people in their minds so that they can actually be able to feel the shift in terms of accepting why this particular issue we're talking about is extremely important. And I think I've said this, but in terms of combining the data with the personal story, so you're showing that this one story is not just an exceptional circumstance, but you're combining data to show that this particular exceptional circumstance is actually not at all. It's happening to very many people who are in that particular circumstance, such as this. So for example, in the JMM case where the ministry had withdrawn the standards and guidelines on the reduction of maternal mortality through unsafe abortion, in court, what was being demonstrated is that these standards and guidelines the withdrawal rather was affecting every form of service delivery that had to do with maternal health care. Because again, abortion is a maternal health care issue. It's not just somebody who does not want to have a child. There were doctors in court who testified as to why the withdrawal has affected even the curriculum in terms of training of medical providers. Combining that data with that personal story then creates a narrative for both for the court as well as for the public as to why it's important to have a framework where unsafe abortion is reduced and abortion as healthcare to ensure the right to the highest attainable standard of health. So just beyond actually just creating that public empathy, it actually demonstrates the urgency towards providing for social change. So much about advocacy, but what is also the role of strategic litigation? And like I've said, litigation is one tool in your box of legal advocacy that you could use. So generally, as lawyers, the way we are trained in when we're in law school is that we go to court to seek justice for our clients. But strategic cases do so much more than that. Not only do they get access to justice for the individual client, which is extremely important, they also secure precedent that can clarify what constitutional obligations are. And I would say constitutional and human rights obligations are. Here, I'll give the example also of the JMM case. That's the abortion case that was litigated in Kenya. The judgment came out in 2019, I believe. And in that judgment, one of the things that the court said, it was a successful case because the court ordered the reinstatement of the both the national curriculum for training for medical providers to be trained on provision of abortion, but also the reinstatement of the standards and guidelines or on the reduction of maternal mortality through unsafe abortion. But part of what also the court reaffirmed was that the right to the blanket criminalization of abortion was actually a violation of our constitution and our human rights standards that Kenya has subscribed to at an international level. That was particularly important because Kenya has a reservation to Article 14.2 of the Maputo Protocol. But what the court was saying is that despite that reservation that we have at international level, our constitution actually goes above that so it is an obligation of the state to ensure that you actually have a framework for provision of safe services, particularly in the context of sexual violence. So that clarification of what the human rights obligation was on Kenya was extremely important because Kenya has a reservation on Article 14.2 of the Maputo Protocol. Secondly, strategic litigation can force administrative or budgetary action, and not just when it's successful. Sometimes even when litigation is unsuccessful. So by way of example, Kellyn had a few years back litigated a case on the isolation policy, on the lack of an isolation policy for TB. It was a successful case, but in the end, the judgment was actually used to force administration, or rather, to guide administrative action in terms of the development of an isolation policy. So that's that's just an example of how this can happen. It's also guided administrative action in the context of I'm sorry, I've glitched a bit. Yeah, it's guided administrative action also in the context of privacy for people living with HIV. So that even when violations do occur, those violations are actually already we've already had some sort of legal action that sets a bar in terms of the standard. By way of example, we can use the maternal health cases. One of which I think also Vivian talked about is the case on detention of women for failure to pay medical bills. We still see it's happening, but whenever we're doing now advocacy around that, we've got a starting point in terms of getting those women released from hospital. So that sort of administrative action already is guided by litigators, or rather by the wins in litigation. Then, of course, litigation can shift public discourse. And I've said sometimes it doesn't have to be necessarily a successful outcome. Again, an example is in the context of the litigation around the reproductive health policy. While the judgment is only a partial win, in the end, there has been a lot of conversations, especially in the past, in terms of what public participation in the context of sexual and reproductive health looks like. And I do know that the filing of that case actually influenced how other policy processes are also going, for example, in the adolescent SRHR policy. So it's not just the win that was being waited for, but the fact that this win, or rather this filing, can continue to influence how the ministry is doing things, that in itself is one way that litigation can play a role in ensuring SRHR services are also outlined and policy is taken. So when we think about strategic cases, really, it's not just about the legal remedy, but it's really around what kind of systemic change there is. And part of what we need to think of as civil society or as advocates is when we're selecting our cases, what would be the greatest impact? And we need to think about impact not just as a win, but what influence in terms of systemic change do we actually want to have? And for us, I think the most important is to make sure that litigation, the court action itself, is also accompanied by good advocacy actions. And there's been various examples about this. I won't go through all of them because I've mentioned in part, and Hortense has mentioned others. But generally, I think one of the best examples in how out-of-court advocacy has been done has come from the HIV space. The communities of people living with HIV have really been able to drive out-of-court advocacy, and sometimes actually in-court advocacy, especially when it comes to issues around forced and coerced sterilization of women living with HIV. We've also seen this in terms of litigation on safe abortion. We've seen this in terms of litigation for respectful maternity care. And this has been extremely important and continues to be an important conversation, especially now that we are having healthcare financing challenges and women being detained in public health facilities. And we've also got the litigation on HIV discrimination. In terms of case selection, I think the most important thing we also have to ask ourselves is, what do we want the case to achieve? And like we just talked about the role of litigation, but when we file the case, what do we want to achieve? Do we want to decriminalize abortion? Do we want to weaken the provisions that criminalize abortion? Those are real questions we need to ask ourselves, even as we interface with our clients. So think about the kind of leverage that we might be able to get when we file a case. I think Kellen had filed a case that when we're working on, part of the leverage that we'd have whenever we speak to policy makers is that they would actually ask us, but what do you want? Like, we have this, then you show what the problem with what is currently there is. And then, you're still engaging with them because they're duty bearers, but you try and explain why the case is there. And that can be used as a leverage in other forms of advocacy that you are doing. We can think about the public impact because we don't want to file cases that do not have public support. And here I'm not talking about from a moralistic point of view, but we want to file cases that are actually relevant and strategic. So that's part of what we need to ask ourselves. Another very important issue is around the client safety and the client consent. We're using people's personal, deeply painful stories to drive systemic change. And this can lead to a lot of backlash. There's traumatization of clients. Sometimes they don't understand what the process is like. Sometimes we as advocates can underestimate the time and effort that it takes to actually take a strategic litigation from start to finish. So we need to think about the safety of the people whose stories we are going to be using. That's something we have to have in mind. And then we can also think about the timing and the political context. What does our political context look like, and is it actually amenable for strategic litigation? For colleagues in Uganda, is it strategic to litigate on or bring additional litigation around, for example, the Anti-Homosexuality Act? It may or it may not be, based off of the kind of clients you get or the things that are going on the ground. So only the people in that space can tell us. But that's part of what you can think about, even as you consider what we want from the court. So those are things that you also have to have in mind, because sometimes you can file a case knowing that politically it may not be the right time, but there is a reason why you are filing. And in the words of the late Forrest Noroji, some things you just must do for the record. Then we think about complementary strategies. What strategies can we take outside the court action that would actually help us in terms of advocacy, or that can be taken alongside the litigation? And in many cases, I know many organizations that do strategic litigation, this is something that has to happen at the same time. You must have the court action going on as well as the out-of-court advocacy. So what kind of movement building are you doing, or are you sustaining? What are the risk mitigation approaches? How are you leveraging on media? Something that I know we learn whenever we're doing feminist litigation is something called the sniff test, where we consider whether we have the skill, whether there is need for that litigation, what impact we want to achieve, and really whether we're able to sustain the case in terms of funding and making sure there's security for the clients throughout. So that's just something that you can also consider. So the other thing is around thinking about the balance between litigation and the negative effects that you're likely to get. We are currently in a space where there's a lot of regression in human rights. I think it may be a worldwide thing because of, I think, the geopolitics, but generally, even within the country, there is a bit of regression because of mis and disinformation, and we need to think about that. Secondly, there's some unintended backlash. For example, you could have re-traumatization of petitioners. So like I've said, we're using somebody's personal pain to drive an agenda. But what strategies are we putting in place to make sure that there's no re-traumatization or harm or further harm that's happening? What if we get a judgment that regresses on the gains? That's part of backlash, and it's part of unexpected backlash because sometimes the courts will not always agree on us. And like we said, while the loss is not necessarily a true loss, then a regressive judgment could still harm some of the progress that we've made. We mitigate this by ensuring we've carefully prepared. We do risk assessments. We, of course, conduct our parallel advocacy to soften the resistance. And advocacy here, we need to think about it in different ways. We can invest time and resources in making sure that we understand the courts that we are going into. We can invest time and resources in making sure that we understand our political context, whether the time is correct. We can ensure that there is security for anyone who's directly involved in the litigation, for everyone generally, but especially for those who are involved in the litigation, because we do have instances where both advocates and clients are pressured to withdraw, or their anonymity is violated. So we need to think about mitigating circumstances like that. Sometimes we can also invest resources in making sure that also the duty bearers, we are carrying them along. For example, again, this is in the context of HIV litigation, a lot of investment was made to make sure that there were dialogues. And I know there's publications around this, which I'd be happy to share, but there were judicial dialogues in terms of judging they're actually called judging the epidemic. So various civil society organizations, including KELIN, I believe, were involved in making sure that duty bearers, so especially within the court system, could understand what HIV and human rights meant. And through those publications, many other people have come to read them. And after that, especially in the employment space, we started seeing improved judgments that actually reference some of those trainings or reference some of those publications. So that's just one idea. And in terms of mitigating both re-traumatization or even or anticipating a regressive judgment. That's just one idea. So these considerations around when to litigate and even how to litigate and how we drive public discourse is extremely, extremely important. There are various cases, of course, where litigation and advocacy efforts have complemented each other. We think about cases, especially on violence against women. This for me is one of the really good ones because the advocacy was driven by prisoners, supported by various organizations. But in cases challenging mandatory minimum sentences, and within the women's rights movement, we had to come together and think about what it meant to have mandatory minimums. So while that litigation was going on, there were, of course, various organizations, of course, who are supporting the litigation, but also who are doing a lot of research and who are engaging with various bodies like the National Council on Administration of Justice to ensure that at least you don't have regressions in terms of the gains made in the Sexual Offences Act. And that culminated in 2023 with the National Council on Administration of Justice actually issuing guidelines that until a court decision is made to the contrary, that the sentencing must be done in line with the Sexual Offences Act. And those were sentencing guidelines that were actually gazetted. So that's just one example because we saw very different duty bearers, including the council itself, government itself, taking a position in terms of what the Sexual Offences Act should look like. I know there is still ongoing litigation on that, but at the same time, the government is also fairly invested in ensuring this protection of women from violence. We've got cases on maternal health. One that came up for judgment this morning is this case on Rachel Mwikali and others versus the CS. And like I've said, in the last few weeks, last few months even, there's been a lot of discourse around what public participation should look like in the context of sexual and reproductive health. And while on that particular score, while the judgment has not been favorable, there is still a better understanding and increased interest in ensuring participation of everybody, including grassroots communities, in the development of national policies on sexual and reproductive health. And even after this case, I remember, was filed, there had been a situation in Nairobi that was being driven by, where the advocacy was being driven by one of the grassroots organization called Women Collective, where they tried to take some of the things within the policy and put them in the national county, or rather the Nairobi county law, and it would have affected access to family planning. And there was a lot of sustained advocacy at grassroots level that eventually led the county assembly to not pass those proposals. The cases on maternal health and respectful maternity care, like I said, we've seen a regression on this, unfortunately, but there had been a sustained effort in making sure that women were actually able to give birth in respectful circumstances. And we had the Linda Mama and things like that, although I do know that there's been a regression on this. And I think I've mentioned like cases on HIV discrimination. In the AIDS Law Project case that struck down the provision on deliberate transmission of HIV within the HIV and AIDS Prevention and Control Act, there was a lot of sustained advocacy by communities of persons living with HIV to demonstrate why deliberate transmission should not be criminalized. I do know that, of course, there's also pending litigation under the Sexual Offences Act, but these are just ways in which collaboration have happened. And just in terms of collaboration, not just between the lawyers, so lawyers can do the legal work, they can leverage on legal advocacy, but it's very important to also sustain a movement that connects the community, that would be able to drive public discourse and not make the litigation a very elite thing that's just being done by these people who speak, high English. So sustained pressure on decision makers cannot be achieved by lawyers alone. It needs a multi-pronged, multifaceted approach. And we do this by knowledge sharing, by speaking to lived realities, by strengthening the movement. And I'm really keen on movement lawyering because it's one of the ways that you're not also co-opting other people's stories and thinking through how to transform victories to systemic change. Many times, of course, we get paper wins, but that we're not able to translate into wins, but also how we can leverage losses to ensure change. So thank you so much. I think that was all I had for you this afternoon, but I'm happy to take questions. Back to you, Christine.
Thank you so much, Valentine, for that very comprehensive and insightful presentation. I have surely learned a lot. So because of time, we'll move on to the next speaker. Kindly bear with us. We're almost running out of time, but just allow us a few more minutes of your time so that we can finish this training and you'll come out of here well informed. So just note down your questions and then we'll have a brief question and answer session after the next speaker is done presenting. So our next speaker is Lynette Manga Mwachiro. She's a lawyer. She holds a Bachelor of Degree, a postgraduate diploma, and she's an advocate of the High Court. She's also a certified professional mediator. So she's a legal practitioner for 11 years with diverse experience in human rights and alternative dispute resolution mechanisms. So she works for the Kenya National Commission on Human Rights. And before that, she worked in legal practice in various law firms. And also the National Legal Aid Awareness Program, NALIEP. So she's currently the Assistant Director for Redress and Legal Service at the Kenya National Commission for Human Rights. So Ms. Lynette Manga, you can proceed to make your presentation. Valentine, could you please stop sharing your screen? Okay, thank you.
My apologies.
Lynette, you're muted. Kindly unmute your mic.
Sorry, I'm having an issue with my internet. Good afternoon, everyone. I have shared my presentation. Kindly allow me to make my oral presentation with my video off. I don't know whether you can see me.
Yes, I can see you, Lynette.
Apparently, I can't see myself, but we can proceed. So the topic I was tackling today is what is the role of the state and independent complaint mechanisms when we are dealing with sexual reproductive health rights. Of importance to us, especially those in Kenya, is Article 21(2) of the Constitution, which codifies the obligations and the role of the state when it comes to matters human rights, and sexual reproductive health rights being one of them by virtue of Article 43(1)(a) of the Constitution. And these are, number one, the state needs to respect sexual reproductive health rights. The state also needs to protect sexual reproductive health rights and also to ensure fulfillment of those rights. This is by ensuring the state has taken positive steps to ensure the enjoyment of these rights. And how does the state exercise its role? Number one, through public education and awareness. Towards the end of the year, especially 1st of December, all of us can attest to the fact that that's World AIDS Day. And there's usually mass campaigns around that with the state. And those in public institutions will note that during that date, the government usually provides free HIV testing centers. Keyword is free, and they're not mandatory. It's usually consensual. No one is forced to take the HIV test. This is one of the ways within which the government seeks to curb the fight against HIV and AIDS. And also the other issue is accessibility of healthcare services, mashinani. I had one of our presenters talk about the Linda Mama, which has been a dicey situation based on now the current shift from NHIF to SHA. Linda Mama has been scraped off, which was one of the mechanisms which was protecting the rights of women when they were having their children. And also through capacity building. And capacity building, this is where the state provides a legal framework which codifies rights. Am I going too fast? Because I'm looking at the term and I'm trying as much as possible to cover. Christine, can you hear me?
Yes, we can hear you. You're doing okay.
Okay, thank you for that. Yes, through capacity building and also the development of educational curriculums. And I'll give yet another example of those of us in Kenya. When we were in high school, there used to be this topic called reproduction in biology, which from the position of the commission is quite limiting. Because when you're talking about reproduction, it only highlights the male anatomy, or rather the male reproductive system and the female reproductive system. And the same seeks to leave out one integral group, which is the intersex persons. And when we're talking about the sexual reproductive health rights of intersex persons, stigma begins from there, at that basic level where there is no clear distinction between male, female, and an intersex. And it is imperative for one of the take homes of the state to ensure that we have inculcated in our curriculum information relating to intersex persons. The other obligation or the other role of the state is to synchronize legislation with the Constitution. Hortense rightly pointed out that there has been a conflict between the Penal Code, which criminalizes all aspects of abortion. The same does not mirror Article 26(4), which gives exceptions to right to life. So for instance, a girl that is above 18 or a woman has procured an abortion as a result of emergency treatment, what becomes of that? There are those people who would say that woman needs to be arrested and prosecuted, but yet again, that falls within the limitations under Article 26(4) of the Constitution. The other thing also, the role of the state is also to provide financial support to the healthcare systems, and this is the government hospitals, and we're talking about clinics, for there to be accessible sexual reproductive health materials. So we are not only talking about the contraceptives, we are talking about the IEC materials. When a woman, a man goes to the hospital, there has to be some sort of access to information by way of either leaflets, brochures, some of those things. And quickly, if I can jump to the role of independent complaints mechanisms, that is the Kenya National Commission on Human Rights. KNCHR is established under Article 59 of the Constitution. It's among the 3 sister commissions, which we have ANGEC, which deals with matters equality and discrimination based on gender. And we also have the Commission on Administrative Justice that deals with maladministration in the public sector. So what does KNCHR do as a key player in implementation, in realization of sexual reproductive health rights? Number one, KNCHR has a promotion mandate. Number two, KNCHR has a protection mandate. When we talk about promotion, how does KNCHR promote sexual reproductive health rights? This is done through conducting of public inquiries. I have shared my presentation. In 2012, KNCHR did a public inquiry on sexual reproductive health rights, which arose from a complaint that had been lodged with the commission by the FIDA Kenya. So some of the issues that had been raised over a decade ago were the issues of SGBV, issues of female genital mutilation. There were issues of wife inheritance, which resulted to most of the women within Kisumu and Kisii County contracting HIV and AIDS. I'm sorry, my internet is flaky. Kindly just bear with me. The other way within which the commission also fulfills its mandate is by providing appropriate redress. So once a complaint has been lodged with the commission, investigations are going to be conducted. And when we talk about complaints, kindly note that anyone can lodge a complaint with the commission relating to a violation of a fundamental right and freedom, and that complaint is going to be processed. Once the complaint is processed, investigations are going to be carried out, and then we are going to have recommendations. And one of the redress mechanisms, especially when we are dealing with a complaint relating to either a state agency, be it the national government or the county government, we usually issue advisories. The other thing we also do as KNCHR is litigation, and I'm glad that Kaylen is here, because the KNCHR has done one matter, actually it's ongoing, so I cannot speak much into it, relating to obstetric violence, where a woman was subjected to 4 failed cesarean section procedures. And one of the ways we seek realization of sexual reproductive health rights is also to move to court by way of litigation and also getting orders which are not only binding to the state, but also binding to private entities. The other thing that we do as an independent complaints mechanism or institution is we conduct research. So we identify systemic issues as what was done in 2012 that resulted to the public inquiry on sexual reproductive health rights in Kenya. The other thing we also do is monitor compliance. Kenya has treaty obligations, and every year, KNCHR usually forwards an a shadow report to the UN on the status of human rights in Kenya. And one of the key things we usually highlight is sexual reproductive health rights, specifically on rights of persons with disability, intersex persons, women and girls. And on the reporting mandate of the Commission, we also forward reports to Parliament on the status of human rights. And we also forward a report to the Office of the President, where we give recommendations on what needs to be done. And based on the last report that we forwarded, we were articulating for the finalization of the Intersex Persons Bills 2023. And the same is also work in progress that will be able to ensure that intersex persons realize their rights. The other issue we are also working on right now is, and those of us in Kenya can confirm, is the sanitary towels bill, which is at the second reading. The Commission forwarded its memoranda and submissions on the same, where we are seeking to have the state provide sanitary towels for girls in primary schools and in high schools to ensure menstrual health. And the other issue maybe on the laws, Vivian had presented a robust legal framework when it comes to sexual reproductive health rights, but I just wanted to highlight one key milestone that Kenya has had with respect to Section 7 of the Persons with Disability Act. This has promoted the aspect of legal capacity, where a person with disability has the capacity to choose. Previously, we had cases where persons with disabilities were subjected to hysterectomies by virtue of their disability. Some of them had undergone tubal ligation on the basis that they cannot be able to take care of themselves. Then that way, they can also not be able to take care of their children. But thanks to Section 7 of that Act, we believe we are going to see a decline as far as that practice is concerned. The other issue I also wanted to raise is the fact that sexual reproductive health rights are not a standalone. They are linked with other rights. And we're talking about the right to life, as Vivian had initially mentioned. We are talking about human dignity, but of importance, especially when it comes to matters of litigation, it is important to link sexual reproductive health rights with Article 25A of the Constitution, which provides for non-derogable rights. And this is the freedom from torture, cruel, inhuman, or degrading treatment, which makes it easier. Because when the court is moved on a non-derogable rights, then there are no limitations or exceptions as far as that right is concerned. I think I would stop there. Sorry, I've been rushing. I'm also looking at the time. I'm also open to take any questions. Over to you, Christine.
Thank you so much, Lynette, for your presentation. We've learned a lot about the recent developments in the legal sector and your role as the Kenya National Commission on Human Rights in addressing some of these challenges faced by key populations. So now we'll just have a brief question and answer session. So if you have any questions, you can raise your hand. In the meantime, I'll just read out one question I saw in the chat, asking, how do we ensure that good court rulings are enforced? How do we put them to a test practically? And also make sure they are cross-cutting. So Valentine, you can address that question. I hope I've read it clearly. Yeah, Valentine, you can proceed to answer the question as I look for any
Sorry,
other
Christine, I missed, I lost you for a minute. Could you please ask the question again?
Yeah, so there's a question from Daniel Digashu. He's asking, how do we ensure that good court rulings are enforced? How do we put them to a test practically? And also make sure these are cross-cutting.
Okay, thank you, Christine, and thank you, Daniel, for that question. I think that's one of the things that's really like vexing us at the moment. What I would say is that we need to start thinking about implementation of whatever judgments we get, even as court action is going on. And the second thing is that we can never rest on our laurels just because the judgment has been won and take it for granted that the judgment will be implemented by government. So as civil society who are working on this thing, the movement building, the advocacy tactics we've talked about, I think one of the things I also forgot to mention is the need to also continue to leverage on media to amplify whatever comes out of court. Those are things that we must make sure continue. Using the example of the isolation policy, the TB case that I mentioned, what I do recall is that Kellen took a lot of time to work with the ministry to actually ensure that an isolation policy was in place. And the government of the day was extremely also invested because they had understood why it was important to have this. But the advocacy doesn't end with the isolation policy being implemented. We still need to continue to work with users of that policy or users, or, within the community to make sure that any challenges are being highlighted and there's an ongoing conversation. So strategic litigation doesn't end at judgment level. In fact, I would hazard to say that the work begins at the point at which you get a ruling. So how do we ensure that they're enforced? We continually engage both the duty bearers and we don't rest in terms of ensuring that the things that we have won on are consistently part of the agenda of the day. This doesn't have to be done by the lawyers. It can be done by everyone who is involved in the litigation or who has an interest in the litigation. The judgment that I've just spoken about that was delivered today on the reproductive health policy, I am aware that a lot of the conversations are actually not being driven by Kelin. They're being driven by actors who are not necessarily in court, but because they see the importance of the issue, they're happy to drive the discourse and the discussion, including women who use reproductive health who seek reproductive health services in public health facilities. So that's one of the ways we make sure it's done. Secondly, majority of civil society, I'm taking for granted that we all come here from civil society. Majority of us engage in various rooms, both nationally as well as internationally. We also have to make sure that these commitments that Kenya has made are also being translated or being spoken of at international level. Majority of us support state reporting or treaty monitoring reporting. So we have to make sure that this kind of pressure is also being amplified also at international level. And I'll give you an example. I think Kenya is coming up for state reporting, I think for the African Children's Committee later on this year. And we've got a lot of precedents that are coming out on adolescent sexual and reproductive health. So that's one of the ways in which we can actually have a conversation with the treaty monitoring body so that in turn, at that level, there can also be actions taken in terms of recommendations given. Another example actually is that we've just also come up for review on the Universal Periodic Review. I know Kenya has declined certain recommendations, but this just means that there's more work for organizations like ICJ, like KELIN, like the SRHR, to make sure that we are actually engaging with government to ensure that those recommendations are the noted ones or rather the accepted ones are implemented, the noted ones, and those that were rejected. We continue to do advocacy around them, especially on issues such as abortion that continue to be live within our context.
Thank you so much.
But Digashu can let us know if we've answered his question.
Yeah, thank you so much, Valentine, for that.
Yeah, no, thank you. My question was answered. Thank you so much.
Okay, so we'll have the last question. Collins Festo, I believe your question is what you've written in the chat.
Yes, that's my question, but because of time, I can rush through it. Collins Festo from Center for the Study of Adolescents. I just want to pick up, first of all, thank the presenters and pick up from where Lynette left by asking, as Lynette has rightly observed, one of the key issues or challenges that we have is the inconsistency between the penal code and what the Constitution provides. And that inconsistency has been the basis for harassment and trumping up of false charges to key populations by police and even arresting officers and even being denied opportunity to utilize certain facilities. So my question is, what exactly, to me, that is the biggest problem, because what exactly are we doing? Especially, you talked about the Kenya National Commission on Human Rights, all these litigations that we are having, but what exactly is in place or mechanism that is in place to try and address this inconsistency? Because due to ignorance, many people use those inconsistencies as a basis to harass people. Just that we are only coming in then to react to what has already happened. You're just coming in to react to an injustice. So I feel if we if we don't address that, then at some point we'll be firefighting, because these abuses will keep occurring and reoccurring, and we'll always be meeting these individuals in court, taking several years, several months in court, spending lots of monies to be able to do all these processes. And yet, in the event there were no inconsistencies, then some of these cases will be clear cut. So my question is, what exactly is in place as the legal fraternity, as advocates, that, or what is it that we can do if nothing is being done to be able to have that inconsistency cleared, so that it then forms the primary foundation for us addressing issues of human rights and SRHR. Back to you.
Thank you, Collins, for that question. It was addressed to Lynette. Lynette, kindly briefly answer the question.
Thank you for that, Christine. So, Collins, what the commission is doing, number one, we did an advisory to the president and to parliament. We have also had several meetings with the DOJ, Department of Justice, to have all the laws synchronized, and I know that is an ongoing process. But with respect to other pieces of legislation, I know there is also pending litigation, but not specifically on abortion. But I think Katiba Institute went to court, but they were trying to deal with the Section 295 and 296. But let me just, because I know there's someone that went to court on this issue. So there's also litigation ongoing. Over to you, Christine.
Thank you so much, Lynette. So I'm not seeing any other questions or hands raised. So now I'll hand over back to Vivian, so that you can tell us the way forward, and then also the panelists can give their final reflections. Thank you.
Thank you so much, Christine, for that. Thank you also to our speakers. Nyokabi, thank you. Lynette, thank you so much. Hortense, thank you so much for your presentation as well. Thank you all for taking time to be with us during this webinar, to share your viewpoints, to explain to us how the situation is looking. In terms of the way forward, I think because of time, we might not have enough time to discuss that. But I think the key takeaway from this discussion is that we need to keep on advocating. We can't stop and say we have court judgments, we have court rulings, and then it ends there. No, we need to keep on advocating. We need to merge litigation and advocacy together so that we can continuously effect change, especially with the emerging issues that have come up, in our various countries, communities, things like that. We also need to remember the importance of self-advocacy as minority groups, sex workers, persons living with HIV, LGBTQI persons. We all need to make sure that we self-advocate as well, share your experiences, also taking note of what Lynette also discussed, sorry, not Lynette, Valentine, what she discussed earlier on with regards to, the trauma and things like that, just being sensitive about these issues. Yeah, I think that's what I can say in terms of the way forward. But having said that, I'd like to bring an end to this webinar and thank you all for joining us. Thank you to our partners, ICJ Kenya, Thank you to all the speakers for your time, and thank you as well to all our participants. This would not have been possible without you. So thank you so much, everyone. Have a good weekend.
Thank you.
Thank you.
Thank you.
Thank you. Enjoy the rest of your day.
Thank you.
Thank you and bye.